I'm doing this live today in sorry. Okay, I'm a French speaker. I'm trying to explain to you everything in English because what I'm doing is for all Canadian, English speaker, French speaker, anyone. What I'm doing, it's a class action lawsuit against Justin Trudeau and 34 others lawyer, elected representative, or ex-elected. I'm the only one. I'm the only one in the world suing in a class action one or more elected representative. And me, I sue the Prime Minister of Canada, notably, for all human beings in Canada. I start this class action lawsuit in the end of March 2024. And I serve through bailiff all around Canada. I serve the legal procedure. I always give available on my X account, Blais. Sorry, I will write then Blais, B-L-A-I-S. There is a bar, and Gloriane, Glorane. It's X account or Facebook, gloriane.blais. I often put the curium link when it brings you to all of my procedure. I just put now. We are now Sunday, November 10, 2024. Then this class action lawsuit, I serve all of the defendants, the 35, including Justin Trudeau, by bailiff. It take a long time. And we had the first hearing September 9. We have the second hearing, very important hearing, November 13. Then it's this Wednesday, November 13. It's at Quebec City courthouse. There is a train station, bus station. There is airport, international airport, and airport for all Canadians. And then all Canadians can come because there is flight from Toronto then. And there is the car, and you may share. Then why it's so important, this hearing, I will explain to you. As I said, I'm the only one in the world start a class action against one or more elected representative. Some sue government about the safe and effective vaccine, fake, okay? They lie to us, you know, or you will know. And the side effects, they are not known as yet. Like there is so much more than all the side effect on all vaccine in our history, world history. Like if we calculate all the side effects of all vaccine, this dangerous experimental injection, the COVID-19 vaccine, is the one. He has more side effects than like 2 addition out of them. And it's not finished, the side effects. It's just the beginning. I'm sorry to inform you. I start this class action lawsuit, yes. Then I was saying that there is some start class action or sue government, Pfizer, Bill Gates, who is the one finance most, is the private most, is the one who by Bill Gates finance uh, WHO, like in the private funding that the WHO receive, then there is a lot of sue and they are all great. But I think it's really important we sue elected representative. Why? It's not because it's not about vengeance or things like that. Okay, I'm really in solution mode for the future of the children, meaning we have to go fast. We have no time to waste. Everyone, I'm not just talking just me, I'm talking all the population, including the judge. Why I'm suing this my legal procedure, it's class action lawsuit. Why I'm suing elected representative? It's because the elected representative, if they were working in their art, meaning they were thinking about the human being in Canada, and if they were working with their art, meaning there would be enough strong front of the lobbyism, the pressure of the lobbyists, the pressure of the pharmaceutical and the pressure of the totalitarian country like China, because we know China have a lot of money, but they doesn't care about the human right. And us, what do we choose? Do we choose to just think about economy? It's very important, economy, I agree. Or we choose to just follow the pressure. The human rights are very important. Even the women, when they oppress people and when they lock down or other so-called sanitary measure, a lot of our near business like village or town business or in our city, our small business, the one like make live our our town, our city, our village. A lot of them like restaurant, they had to close. Then they don't care really about our life. Meaning, if we want that elected representative are enough strong to be to protect the human being, even the pressure of lobbyists, pharmaceutical or totalitarian country, we have to have elected representatives strong with in their art. Then to sue 35 in Western world, in Canada, my country, it's to give an example. It's to say, what do you want to do, all elected representative in Western world? Do you want to straighten and be strong for human being in your country? Because the Western world is the place there is still hope. It's not in totalitarian country there is hope for human right. Then are you able, current elected representative, to be enough strong in your art and protect the people, the human right in your country, or dismiss, go away? Is the only solution, and we have to go fast. Then I sue 35 of I sue prime minister, ex-prime minister, federal one, and provincial one, and territories one. Prime minister, ex-prime minister, minister of health, ex-minister of health have said repeatedly, repeat and repeat, then it was a safe and effective vaccine when it was a lie. This is the fault, the legal fault. When I start the class action, as I said, I'm the only one do it. Then why I start? It's because I was scared. I was worried about the Canadian right, because there is the legal concept, it's prescription in French, expiration of the right. Then if you want to sue in 10 years, it will be difficult, because they may say the judge, after all the trial, it was expired. You're right. In Quebec, it's 3 years. 3 years from the knowledge of the fault of, or from the knowledge of the damage. But it would, after 3 years, it's always more difficult. You have to prove you didn't know, why you didn't know, na na na. Then, when I started, it was in the end of March 2024, 3 years after they began to lie and repeat to lie. And no lawyer, neither in Canada, neither in the world, start this class action to against one or more elected representative. Then I decide to sue 35. I may sue 100, but it was like to an example. At least I wanted it sure to sue Justin Trudeau. As I said in a live, I think it's yesterday, with Stéphane Sévigny, it should be the RCMP sue Justin Trudeau about this. It's not supposed to me as to take all the risk of my life. It should be the RCMP take care of this criminally. My sue it civilly, but it should be the RCMP take this. But they don't do. They are not there anymore for the people we can see. I'm sorry, for the people work with, and they want to be a right and in this RCMP, but the courage is from the art. If you don't work with the art, you cannot have courage, and the courage is necessary to integrity. Then I start this class action lawsuit, but the point is I have been lawyer, 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 not liar, lawyer, during 22 years from 1999. I was expert in health law. I'm still expert in health law, and I was working for the victim. I was working in civil litigation, very big civil litigation, including in medical malpractice for the victim case that I win. One of them is very known for, like, from the community, the lawyer and the jurist and the professor in law in health law, because it was in obstetrics, very difficult to win. I make the case win. I obtained the gain cause in French. I obtained, I went for my client, I will say like that, at the trial, at the Court of Appeal of Quebec, and also at the level at the Supreme Court of Canada for that case. But I become a whistleblower as lawyer, expert in health law in spring 2021, when I wanted to alert Canadian first, the French speaker, because I'm so better in French. And after, in September 2021, I crossed Canada to alert in English, the Canadian English speaker, about this dangerous experimental injection. And they make me lose my, and I begin to say, when they start to talk about inoculate with this lie, the safe and effective vaccine, when we knew that it was not safe and neither effective, because it was still experimental. You cannot say that it's safe and effective. Then when they begin to talk about inoculate children, I begin to see crime against humanity. In spring 2021, as lawyer expert in health law. And I have another case that I bring to Supreme Court. It was a case of governmental corruption, civil case, that I bring for my client victim, a businessman victim of corruption. I bring to all the steps of the Canadian judiciary system, and the judiciary corruption make win the governmental corruption. Then instead to analyze what they do, the judge to not give justice, they attack the lawyer, strong, the one think about justice. And the judicial corruption attack me in the last 4 years. Since November 2024, they attack me, and they disbar me. They even order me a psychiatric examination that I refuse, because I knew that all the proof is legal, the juries are able to read, but they don't want to admit that the Canadian judicial system are not there when there is governmental corruption. They prefer like to be corrupt too. Then I bring the case, then they attack me. They make me lose my, disbar me. I'm the only one. Then they disbar me for on this case, and also on my words as crime against humanity. As a lawyer, I'm not a scientific, I'm not a physician, I'm a lawyer. And a lawyer is there for the voice, different voice in a democracy. Then I'm the only one get disbarred in Western world. I'm the only one lawyer for those same words get disbarred. And I bring that case, my disbarment, to the judicial, the Human Rights Council of UN, United Nations, in September 2024, when all the judicial system fail on the case, fail of my disbarment, even including the Supreme Court of Canada. Then I get disbarred. And when I start the class action lawsuit, upon the Quebec law, it needs to have a lawyer to represent the representative of the group of the human being. Like I start as the representative of the citizen, represent all the human. I propose to the court as a representative, as a citizen, to represent all human being. But the representative upon the Quebec law needs to be represented by a lawyer. Then I said I will start the class action lawsuit, and during that time the case was going to the Supreme Court, my disbarment. The Supreme Court will give justice, and I will be able to continue to represent all human beings in Canada, to make sure that human beings in Canada don't lose their right on the fake, safe and effective vaccine. Big lie. And but instead to give me back my title as lawyer, the Supreme Court of Canada failed September 12, 2024. Then I bring the case to the Human Rights Council of United Nations. But the point is the United Nation and the United Nations, they never give me back as yet. It's 2 months now, nearly 2 months, a receipt that, yes, like an email, yes, we receive, we will analyze, it will take time, this time. Then at the first hearing of the class action, the lawyer for Justin Trudeau and others, but I will say the lawyer of the Prime Minister of Canada, sent to the court, listen, judge, sent to the judge, Gloriane.blais is not represented by a lawyer, she's not a lawyer. Then we ask to dismiss the case of class action lawsuit. Then I said to the judge, listen, we cannot make lose all the right of the Canadian. And my title is On the Hands of the Human Rights Council, UN, and I'm giving you, judge here in Quebec City, all the proof that I'm right about my disbarment. Then he said, I asked the lawyer of Justin Trudeau to deposit procedure about what they want, like to stop the procedure, meaning to give a, I don't know in English, in French it's disculpation, like if like they dismiss the class action lawsuit, it's mean the Canadian has no right because what? Because the Canadian judicial system failed on the case of gloriane.blais, on the case of disbarment. Even the Supreme Court of Canada failed. Then the most courageous lawyer, or one of them, we cannot start the class action that nobody does against elected representative because the Canadian judicial system failed on our disbarment. Then I deposit a plan, argument plan to answer to the procedure of Justin Trudeau to try to say, okay, I can leave and no be sued. And the plan of argument, my point is the Prime Minister of Canada, want to protect himself from the big lie he did repeatedly to human being in Canada, because in using the failure of the Canadian judicial system. Then I said, wait, and the Human Rights Council will take a decision, and during that time, nobody will lose their right in Canada. Then wait. Then I sent after to deposit the plan of argument, I sent to the Human Rights Council a letter. Then I offered them to meet me in November 1st in Geneva, where there is their office, like UN, United Nations has two offices, New York, two head office, New York and Geneva, but the Human Rights Council is in Geneva. I was around Geneva, then I said, I would like, I request you, the Human Rights Council, to meet you in your office in Geneva the November 1st. I never received a receipt of acknowledge that they received my case. Even I have the receipt of the postal receipt. And they never said to me if they can meet me. And now there is this hearing in November 13, this Wednesday, that may make lose all the right of Canadian to sue their Prime Minister, including Prime Minister. Then I send a formal notice to the Secretary General of UN, United Nations, Antonio Guterres. I post on my Facebook and my X account, and I send by register mail the November 5th. I sent to a formal notice to say to Antonio Guterres that make sure that the Human Rights Council will not, with their delay, protect the fault of the Prime Minister of Canada. If you don't react when it's time, why you are there? And then I will read first. I was going to read the application, but I will read first my formal notice, because I explained mostly like the why I wanted to talk to you. Just want to say first, and after I will read the document, okay? it's 25 minutes already that I talked. After I will read the document, but the live will be 1 hour. Then if I don't have time to read everything, the live is 1 hour because I don't want to. I want to do a live in French too, and there is a demonstration for the case. Currently, there is a demonstration in front of the Supreme Court of Canada for the other case that I'm holding to abolish a first public health act in the world. I'm the only one, on my knowledge, attack a whole public health act, and the Supreme Court has a file in all this procedure to make. I want to make sure that we can have this trial in Montreal courthouse. There is a demonstration. Why I'm not there? It's because I want. It's too big case. Do you understand? Too big case plus the proof that I have in my disbarment, and the Supreme Court of Canada and our judicial system are not there for the people, for when there is corruption, governmental corruption, or you may say abuse of power of government. Then I need to protect my life. I received threat, and then since April 2024, I leave Canada. I mean, the April 12th, I leave Canada, and I request asylum in France. And I had my hearing the October 25th. I will receive soon their decision, and soon, I don't know, because they may take more delay. They sent to me to take the decision, and I give to them all the proof that I received persecution from the Canadian judicial system since the last 4 years, with my disbarment and the threat I received too. Then I'm not there in the demonstration from the Supreme Court of Canada. Other Canadians are there, and I invite you to be there this Wednesday, November 13. If you want to keep your right in live, November 13 at 9 a.m. Eastern time in Quebec City. The Quebec City courthouse is just near the train station. It's just near we can walk. It's very near, just near the bus station, and the airport is. You take a taxi, you will be in Quebec City courthouse from the airport, like 15 minutes. It's a beautiful small city, as you probably know. Then I will read to you the formal notice that I sent to the, sorry, because I have to look like that because I don't have everything print. I don't have anymore all my office. I live in France with the material that I can for now. The formal notice sent to the UN, the UN Secretary, no, I will do, sorry. Like, it's not so beautiful like okay, my formal notice, sorry, I know it's my formal notice I sent to the UN, United Nations Secretary General Antonio Guterres, the November 5th 2024, by register mail, with acknowledgement of receipt from Post France, for the right of Canadian, the right to keep the rights to sue. Okay, you may have the rights if the delay to sue is expired, and it's difficult. And it's about the safe and effective vaccine. After, and the formal notice, I have to open under it's right. On September 20, 2024, you received my complaint against Canada. Shortly afterward, you received my supplementary letter asking you to meet me in your office in Geneva on November 1st, 2024, a letter which includes my important argument plan of the class action lawsuit against Justin Trudeau and 30 other lying elected representatives, comb safe and effective vaccine, end of comb, a letter and argument plan which inform you of the urgency for you to make a decision for the safe, it was in French, okay, the letter, make a decision for the safeguarding of Canadian rights. The hearing in Canada when Canadians may lose their right forever, it's November 13, 2024, this Wednesday. Why it is urgent. No reply to my request for a meeting, and even no acknowledgement of receipt apart from the Post France. Yet, this ignorance will only result in protecting Canadian Prime Minister Justin Trudeau. This ignorance is a denial of the effectiveness of human rights for which the Human Rights Council has international responsibility. What good is the United Nations Human Rights Council if it does not deliver when humanity demands it? Consequently, I publicly summoned, because I post on Facebook and X too, I publicly summoned the senior leader of the United Nations, including Antonio Guterres, to ensure that the United Nations Human Rights Council has making a position with competence and integrity on my complaint date of September 13, 2024, before November 13, 2024. If not, you will be an accomplice in exonerating this crime against humanity. Exonerating this crime against humanity. Sorry for my English. May love make you courageous, courage being necessary for integrity. This is my letter that I sent to the Secretary General of United Nations, Antonio Guterres. He will probably receive formally this Tuesday, the 12th. But I published on internet before, and they just have to write to me by email to say, okay, we will take 2 weeks, 3 weeks to look on your file, and I will be able to inform the judge, take 3 weeks, I will give you news after 3 weeks. I just have to have something first to make wait the judge, to make sure Canadian rights are not lost forever. And I will name all the defendants, the 35 defendants that I sue with the class action: Justin Trudeau, Patty Ashdoux, Jean-Yves Duclos, Marc Holland, Mona Fortier, Joe Savikatak. Oh, sorry, I didn't think, but I will say which level they are. Justin Trudeau, fédéral. Patty Ashdoux, fédéral. Jean-Yves Duclos, fédéral. Marc Holland, fédéral. Mona Fortier, fédéral. Joe Savikatak, Nunavut Territory. Lorne Kuzugak, Nunavut Territory. John Main, Nunavut. Andrew Furry, Newfoundland and Labrador. John Aggie, Newfoundland and Labrador. Stephen McNeil, Nova Scotia. Tim Houston, Nova Scotia. Michelle Thompson, Nova Scotia. Dennis King, Prince Edward Island, James Aylward, Prince Edward Island, Ernie Hudson, Prince Edward Island, Blaine Higgs, New Brunswick, Dorothy Shepard, New Brunswick, François Legault, Québec, Christian Dubé, Québec, Doug Ford, Ontario, Christine Elliott, Ontario, Sylvia Jones, Ontario, Heather Dorothy Stevenson, Manitoba, Wab Kinu, Manitoba, Scott Moe, Saskatchewan, Everett Hindley, Saskatchewan, Jason Kenney, Alberta, Taylor Chandro, Alberta, Jason Copping, Alberta, John Organ, he was at that time in British Columbia, Adrian Dix, British Columbia, Sandy Silver, Yukon, Caroline Cochrane, Northwest Territories, and Julie Green, Northwest Territories. After, I will read to you the application. It's called the first procedure. It's the application. Oops, it would be difficult. Sorry. Because all the procedure are available on the Decurium link that I put on my Facebook and X just today, another time. Then it's an application for authorization to institute a class action and to be a representative. It's a modify one. It's not important. The translation, it's not a legal one, okay, just to permit all Canadians to have the explanation in both official language, but it's not a legal one in English. Everything is in French. I think I will put like that. The application wish to institute a class action on behalf of person belonging to the following class, in which it is a member, namely human being who make up the Canadian population. The fact which will give rise to an individual action by the applicant and by each of the class members against the defendants are the application, a lawyer from the applicant is myself, a lawyer from 1999 to 2022 is an expert in civil liability, including medical malpractice, and holds a graduate degree specializing in health law and policies from the University de Sherbrooke, as appear in exhibit, including judgment in all the court proceeding in which she was as won her client's case in a landmark case in obstetrical medical liability. In 2021, the applicant courageously became the first jurist in Quebec and, to our knowledge, in Canada to be a whistleblower regarding the dangerous experimental injection as a lawyer expert in health law, as can be seen notably from these two live streams, date May 27, 2021 on Facebook, and date of September 14, 2021 on Facebook, now available on the YouTube channel. The first one, it was in French. The second one was front of the Manitoba Parliament in Winnipeg. One of them that I do a live. I do many live in English. Also, on November 1st, 2021, the applicant filed an application for leave to appeal to the Court of Appeal of Quebec concerning the dangerous experimental injection. This legal action was the first proceeding at the level of a court of appeal in Canada and to the applicant's knowledge in the world concerning the dangerous experimental injection. The applicant pleaded on January 31st, 2022, before a panel of 3 judges of the Court of Appeal of Quebec, including Christine Coton Forsenic expert report signed and filed in January 2022. An expert report that to date has never been contradicted by anyone in the world, as appear from part of the application for leave to appeal. I just want to inform you that Christine Coton, she's from France. She, after to write her expert report and sign in January 2022, a very good expertise from the Pfizer document, own document, own Pfizer document. She published 1 year after a book in French, tous vaccinés, tous protégés, then all vaccinate, everyone protect, interrogation. And it's an up-to-date report, and it's easily to understand, very interesting. And recently, like few weeks ago, maybe 2 or 3 weeks ago, she published the same book but in English with a new part at the end, and she make available free. It's free on internet if people want to download, and she ask a donation if the person want, but it's not necessary. Then I will put the link to a download and the information, the one French speaker, to add the hard copy. Very interesting to have the hard copy. This dangerous experimental injection caused excess mortality in Canada and Western countries of more than 20% and cause other serious current and future side effects in the general population. The National Citizen Inquiry addressed the situation of inoculated person in its final report. This, the National Citizen Inquiry, I give the link, but it's available on internet for everyone in English. The defendant, by virtue of their respective public and constitutional function, were or ought to have been aware that the dangerous experimental injection could not lawfully be characterized as a safe and effective vaccine, as that this fraudulent designation constitute inter alia a fraud. Despite this, the defendant personally lied to the Canadian public and beyond by saying from their own mouth this serious lie, safe and effective vaccine. This lie stated by each of the defendants and even repeated constitute gross and intentional fault, intentional according to the teaching of the Supreme Court of Canada. This gross and intentional fault on the part of the defendant has been made in the impossibility of free and informed consent for Canadian population. This gross and intentional fault on the part of the defendant caused the inoculation with the dangerous experimental injection of the majority of human beings in the Canadian population, and for the human being who refused to be inoculated with the false and effective vaccine, this gross and intentional fault on the part of the defendant caused them considerable social and economic losses and damage to their physical and psychological integrity, even to the point of depression, suicide attempts, and suicide. Some young children were subject to the games of cowboys and Indians in Canadian schoolyard, a game adapted in view of the gross and intentional fault of the defendants of the games between the vaccinated and the unvaccinated, those not inoculate with the dangerous experimental injection were chased and even beat by their classmates. The National Citizen Inquiry dealt with the situation of the uninoculate in its final report. Legally and constitutionally, the defendants do not have immunity when they lie to the population, even less when their public and constitutional function gave them a bond of trust with the human beings who make up the Canadian population, a bond of trust that they have betrayed. Consequently, the defendants are in solidarity with others liable for all damage caused to human beings who make up the Canadian population, damage caused by their gross and intentional fault. The defendant gross and intentional fault is an infringement of the fundamental, constitutional, provincial, and international rights enshrined notably in the Canadian Charter of Right and Freedom and the human beings who make up the Canadian population. Of the human being who make up the Canadian population. Such damage include inter alia non-pecuniary compensatory damage such as physical and psychological suffering and death, compensatory pecuniary damage such as loss of income and cost, and punitive damage under Section 24 of the Canadian Charter of Right and Freedom. The composition of the class make it difficult or impractical to apply the rule of on retainer or joinder of procedure, in that the class include a very large number of human beings, namely the human being who make up the Canadian population. The identical, similar, and related question of fact and law between each class member and the response that the applicant seeks to have determined by the class action are to dot the determination of gross and intentional fault by proving the lies in connection with the dangerous experimental injection. The question of fact and law peculiar to each of the member are the damage suffered by each member and its causal link. It's appropriate to authorize to bringing of a class action on behalf of the class member. The nature of the remedy that the applicant intends to pursue on behalf of the class member is an action for compensatory and punitive civil liability. Then this is mainly my application. There is a lot of document. I just want to show. This is print in two sides. Okay, it's printed two sides. Then it's quite big. Okay, for the application, and in each step the case will be bigger. But it has a lot of proof already. I will finish to read. Sorry. Thank you for your patience about my English accent. I will read my plan of argument, what I deposit to the Superior Court of Quebec for the hearing of November 13, this Wednesday. Then this is they call in my, because it's a translation with deeply. Myself, I'm the plaintiff or the applicant. Okay, then it's the plaintiff or applicant. It's myself. Okay, the plaintiff plan of argument in anticipation of the hearing of the motion to dismiss by the Prime Minister of Canada, Justin Trudeau. Canadian Prime Minister Justin Trudeau is trying to take personal advantage of the lack of integrity of the Canadian justice system, including the lack of integrity of the Supreme Court of Canada. As mentioned in the application for authorization to institute a class action, is an expert in civil and medical liability and holds a graduate degree in health law and policy from University de Sherbrooke, as a pair exhibit P1, P2, and P3 in the application for authorization to institute a class action, including judgment in all legal procedure in which she obtained ruling act for his client in a landmark case on obstetrical medical liability. The plaintiff is most likely the most qualified for the litigation on the merits of this class action of all the lawyers present in the file, meaning the defendant's lawyer. The plaintiff has suffered unlawful and abusive persecution by the Canadian judicial system, particularly in the context of the two judgments of the Supreme Court of Canada, date of July 8, 2021. This one is when the judicial system protect the government corruption illegally, and the judgment July 12, 2024, when they protect the judicial corruption and governmental judicial, instead to protect the lawyer was the most straight, the most for the justice, and disbar me. Okay. As appear from the plaintiff complaint to the United Nations Human Rights Council, date September 13, 2024, a copy of the complaint redact for the plaintiff personal security and proof of receipt by registered mail to the United Nations Human Rights Council on September 21. Finally, they received September 20. In essence, the plaintiff complaint to the United Nations Human Rights Council state to that as a member, then this is my plain complaint. The extract that I put is the complaint to the Human Rights Council, okay? Because the Canadian judicial system were not enough straight front of the governmental corruption. As a member of the Quebec Bar 2000-200-279-5 in Canada, Canada being part of the Commonwealth Kingdom, then under Queen Elizabeth II and now under King Charles III. In 2011, I am mandated to represent the client Martin Lajeunesse against the abuse of governmental power against Investissement Québec, a crown corporation of the government of Quebec in Canada, a crown corporation where legally the Prime Minister, the Prime of Quebec in Canada, then Jean Charest, can intervene. The result was a legal action for 35 million of Canadian dollars brought by my clients against Investissement Québec of the Quebec government under Premier Jean Charest. A lengthy trial took place in fall 2020, and at the end of this trial, Quebec Superior Court Judge Martin Bureau handed down a final judgment in November 2020 that deliberately failed to name a complete portion of my client's solid evidence. Then it didn't name a big portion of the proof my client like the very solid. Then it didn't name in the judgment and never consider. Then it was, by example, judicial confession, black and white writing, and pre-contract legal opinion by my client's former lawyer, and more. and the judgment of Martin Bureau did not assess the credibility of any witness, fact witness, and expert, even though this was his judicial duty. The judge of the trial therefore rendered a fraudulent judgment, a judgment with a deliberate lack of impartiality and judicial independence, which enabled the state-owned company under Premier Jean Charest to win its case illegally. As your it's not good translation. As lawyer, I'm taking the case to the Court of Appeal of Quebec in December 2020, which these clear and shocking allegations. At the stage when no appeal record had been created, at the stage when the party did not have to fill their evidence, at the preliminary stage, a panel of 3 judges of the Court of Appeal of Quebec rendered a preliminary judgment, dismissed my client's appeal in its own right. A panel of judges who refused to look at the potential evidence to protect the abuse of government power, to protect then Premier Jean Charest, to protect their friends, the trial judge. As a lawyer, I'm filing an application at that time for leave to appeal for my client to the highest court in Canada, the Supreme Court of Canada, in March 2021 with 14 volume of evidence. Shortly thereafter, the Chief Justice of the Quebec Superior Court, the boss of the Quebec Superior Court judge, including the trial judge who had rendered a fraudulent judgment, filed a request for an inquiry against me with the syndic of the Quebec Bar, the Bar of Quebec, for my remarks, which were indeed shocking, but which were supported by 14 volumes of evidence in my 20-page factum in my application for leave to appeal to the Supreme Court of Canada, even though the Supreme Court of Canada had still not rendered its judgment. In May 2021, Daniel Gagnon, assistant syndic for the syndic of Bar of Quebec, Barreau du Québec, filed the first disciplinary complaint against me for life based on this request for an inquiry by the Chief Justice. Later, when I submit Daniel Gagnon to my cross-examination, we learned that Mr. Gagnon had never read a single page of my evidence in the said 14 volume. He had confined himself to reading only the brief, meaning the allegation, no proof. He didn't read the proof. These 2 admissions under oath will take place at 2 hearings, a preliminary hearing on October 8, 2021, and at the trial of the disciplinary complaint on March 14, 2022. On July 8, 2021, the Supreme Court of Canada failed in its public and constitutional responsibility by rejecting the application for leave to appeal with its 14 volume of evidence, by refusing to review judgment with a deliberate lack of impartiality and independence, even though this is a part of their constitutional obligation, and moreover, only the Supreme Court of Canada could do so. It's the only case in Canada in the legal history with evidence of these serious allegations. Yes, it's the only case that has like that with with evidence, not just allegation. The disciplinary complaint against me continue. I saw no point in Canadian justice withdrawing my application for leave to appeal despite the illegal violence of the Canadian justice system, including the Syndic of Bar of Quebec. I see no point in subjecting myself to the abuse of government power, nor to the abuse of judicial power, because there was never any question of my agreeing to be part of a play. In fact, there was never any question of my betraying my country, Canadian and the citizen of the Commonwealth Kingdom. I'm very straight. Then there was never any question of betraying my country. The trial, because what to lie in the judicial system, for me, it's not a judicial system. The trial on the discipline, I'm still in the an extract of my complaint to the Human Rights Council, that it's in my plan of argument that I will plead Wednesday the 11th of 13. The trial on the disciplinary complaint set for March 14, 2022 was approaching, and they all knew that my evidence in the said 14 volume was solid. Daniel Gagnon wrote to the board of directors of the Quebec Bar, asking them to order me to undergo a psychiatric examination, all without my knowledge. The board, there was an hearing. The board of directors of the Quebec Bar issued a psychiatric examination order against me on February 3rd, 2022, without my knowledge, without informing me of the hearing, without allowing me to submit my evidence, and without respecting the elementary principle of justice. I refuse to submit to this abusive order, since it is the jurists who are the member of the board of directors of the Barreau du Québec who are competent to read my legal evidence in the said 14 volume, and not psychiatrists in particular. The member of the board of directors of the Barreau du Québec illegally and improperly disbarred me permanently on March 10, 2024. Consequently, closed my law firm and prohibited me from giving any legal advice. I'm therefore prohibited from supporting myself and my young family on the basis of everything I have built up over the past 30 years, beginning of my bachelor's degree in Quebec civil law in 1993, beginning of my post-secondary high school study in post-high school study in 1991. My appellants factum before the Quebec Tribunal des Professions du Québec on this psychiatric examination order and this permanent disbarment illegal and abusive. I give a link of this information to get this information. On March 14, 2022, I have my trial on the disciplinary complaint, at the end of which an unlawful and improper conviction will be handed down with the penalty of an unlawful and improper disbarment for 8 years. They find me guilty of failing to respect the administration of justice, whereas I have the evidence that it was the judge, including the judge of the Supreme Court of Canada, who did not respect the administration of the justice. I take this decision on guilt and sanction to all level of appeal, on appeal to the Tribunal des professions du Québec on judicial review to the Quebec Superior Court via an application for leave to appeal before a single judge in the Court of Appeal of Quebec. All of them fail. All of them protect the abuse of government power and the abuse of judicial power. It's so violent. On May 17, 2024, on my own behalf, I filed my application for leave to appeal to the Supreme Court of Canada on the disciplinary file, with now 19 volumes, including the original of 14 volumes of evidence from 2021. In view of constitutional law in Canada, on May 17, 2024, I served the 19 volume of my application for leave to appeal on the Governor General of Canada, Mary Simon, and the King of the Commonwealth of Kingdom, King Charles III. They will never intervene, although they must protect Canadians from treason. On September 12, 2024, the Supreme Court of Canada dismissed my 19-volume application for leave to appeal. On September 12, 2024, the Supreme Court of Canada demonstrated to Canadians that it is not there was not there for justice in the face of abuse of governmental power and abuse of judicial power. By its rejection, the Supreme Court of Canada endorsed with willful injustice in the circumstance of the solid evidence to shocking but true allegation. This judgment of the Supreme Court of Canada, dated September 12, 2024, state that it is dismissing by application for my application for leave to appeal the judgment of the Court of, I think I did quite because it's 1 hour 6 minutes. I wanted to not be oh yeah, I will. It's not all of my complaint to the Human Rights Council, but I will I explained quite I will just finish with this. Canadian Prime Minister Justin Trudeau, this is my plant of argument. I'm not in the complaint in human rights. Canadian Prime Minister Justin Trudeau is trying to take personal advantage of the lack of integrity in the Canadian justice system to get away with his serious lies about dangerous experimental injection. The position of the United Nations Human Rights Council will have a direct impact on the Canadian justice and the reinstatement of the plaintiff's legal status. In order to respect the constitutional and international principle of the separation of power and judicial independence, taking a decision on Canadian Prime Minister Canadian Prime Minister Justin Trudeau attempt before the decision of the United Nations Human Rights Council would be unacceptable and even indecent in a Western democracy. Consequently, in its interest of justice to avoid the position of the United Nations Human Rights Council on the plaintiff complaint before depriving all Canadian search right. I think it's quite. Then this is what I will play part of this. The judge has probably read most of them, then they will know what I'm doing. Then I invite you to be there in Quebec City courthouse this Wednesday, November 13, 2024 at 9 a.m. before. The number of the room will be right, and invite you to support what I'm doing. I'm the only one do this. and I'm the only one do the procedure that I'm doing in Montreal City and in Supreme Court to abolish the Public Health Act. Then I have a GiveSendGo and for people access Interarc. Then it's for all the Western world. It's very important. Thank you very much. And please share. I will share on X, on Facebook. Please share to everyone speaking English. I will begin in 1:30, then in 10 minutes, this live in French here on YouTube, and around 3:30, well, on the Stéphane Sévigny Facebook page, we will have a live to talk about this hearing this Wednesday at the end of the demonstration of today, front of the Supreme Court of Canada, about the case to abolish our first Public Health Act in the world. Then this case, this Wednesday in Quebec City courthouse, is for the class action lawsuit against Justin Trudeau, and it's to keep the rights to all Canadians. Thank you very much.